All right, folks, let's talk about staffing and recruiting non-compete agreements. I'm just going to jump right in. So I have been on this particular issue for at least the past 7 or 8 years, and I find it absurd that here we are in the year 2020, and this is still, treated as a real thing. So I'm just going to jump right into this, okay? Number one, as a background point with regard to the legal landscape here. Lots of people who follow me, they're already familiar with this, but for those folks who are not particularly familiar with this area of law, with non-compete law and restrictive covenants and restraints of trade, let me lay it out for you, okay? Non-compete agreements are restraints of trade. And restraints of trade are illegal unless they are reasonable. So in the non-compete context, a restraint of trade, a non-compete agreement, should be declared illegal if it is not reasonably necessary to protect a legitimate business interest. Okay? What's a legitimate business interest? A legitimate business interest can take the form of confidential and proprietary information that is unique to the company, that is valuable, and that could be used by a competitor to engage in unfair competition. Okay? Point blank. Let's get that through our heads, people, okay? The notion that somebody can slap the label confidential on a file or a document and then say, Your Honor, they've got our confidential information, so this non-compete must be enforced to protect that confidential information. That is preposterous, and that is not how the law works. It's not how the law is supposed to work, because if we let people run around and leverage the fact that they label something confidential in order to restrain trade and competition, that is going to create a market problem, and it already has created a market problem, and it's at the core of this epidemic of non-compete abuse that is running rampant in America and ruining people's lives, legitimately, putting people out of work, preventing them from taking care of their families, providing for their loved ones, and ruining people's lives. It is an absolute mockery of American competition and American capitalism. And yet, many people worship at the altar of non-compete agreements. I've said it once and I'll say it again. It is the sacred cow of modern American business. And you know what? It needs to be slaughtered. So that's one, confidential information or trade secrets. But the point there is, it's not just because you labeled it confidential. It legitimately has to be so important and so secret and so valuable that if it fell into the hands of a competitor, they could use it to engage in unfair competition. That's one. Two, it could be special or protectable customer relationships, right? And in the non-compete context, we often have lawyers and litigants and sometimes even judges say, well, you worked for, company A over here, and now you're doing business with these same customers, and we can't have that. Well, here's the reality, right? If it was 1975 and you're, somewhere in upstate New York, and you have a list of customers who are buying, heavy machine equipment, right? For industrial projects, for construction, whatever. If you have a list of your big buyers, right? Or let's say the same thing. It's 1975. You're in upstate New York. You have a list of people who buy tools. Right? They buy tools from you. And these are private individuals, okay? Who, you can't really figure out who the clients are, and this customer list you have, okay, maybe then it's valuable, right? But we're talking about 2020, okay? And a lot of these non-compete cases, especially in the staffing and recruiting context, which we'll get into, we're not talking about protectable customer relationships. We're not talking about, a customer who goes to one guy to buy his wrenches. And for a fact, Bob is living out there on a farm on the outskirts of town, and I know he buys a lot of wrenches because I've been his wrench guy for the last 10 years, and now I'm going to a competing company, and I'm just going to try to take Bob with me, and I have this sort of secret knowledge about what Bob buys because he's not shopping around, because I'm his wrench guy, right, for a decade. That is not the reality of the world, people, not in 2020. And to pretend like it is is absolutely preposterous, and it's an emperor has no clothes moment, okay? But the reality is you can have a non-compete in place or a non-solicitation in place to protect, special customer relationships. And in some jurisdictions, they actually have legal term of art for the type of relationship. In Florida, they call it a substantial customer relationship. So what is a substantial customer relationship under Florida law? I have at least 2 cases that I have litigated and where I have extensive written decisions that address the concept of a substantial customer relationship. A substantial customer relationship is more likely to exist where the customer information or the customer's identity is not easily obtained by competitors through publicly available means. There's a long-term business relationship. There's an expectation of ongoing business. Sometimes there's a contract. The relationship is exclusive or near exclusive. These are factors that go in the direction of it being a substantial, protectable customer relationship, right? If it's exclusive, contractual, long-term, continued expectation of business, nobody else can get access to that customer, then yeah, there's a very good chance that it's substantial and protectable. On the flip side, if the customer is using multiple vendors and providers, if anybody can go on Google or LinkedIn and find the customer and compete for that business, and there really is no continued expectation of anything more than an opportunity to compete and buy for the business, and it's highly competitive, well, then that doesn't look like a substantial customer relationship and does not look protectable. The final interest that we often see in the employee non-compete context, as opposed to the sale of a business context, sale of a business is entirely separate and distinct from this. That's a whole different universe. We're talking employment non-compete agreements. So in the employment context, the big 3, the third big interest that you see companies try to leverage is training or education. But the caveat there is that it has to be extraordinary. You don't know how many cases I have seen. I was in a case one time where it involved, pharmaceutical industry. And the lawyer on the other side, it was in a preliminary injunction hearing, and the lawyer on the other side is up there grandstanding and putting on his case. And he says, when you were in pharma, you were dealing with, this particular drug. And the drug had a really strange name. And he says, well, where'd you learn how to pronounce that drug? Well, you learned it from the training they gave you. And that was his sort of big piece de resistance. But you know what? Sadly, that sort of case, that sort of logic, right? Just we have some confidential information, and now he's got our customers, and we gave him some training. That has quite frequently been enough to obtain an injunction, at least in many trial courts throughout America. Certainly there are many jurisdictions in America where if the plaintiff goes into court and makes that basic argument, the court's going to give that plaintiff an injunction. Why? That's because there's a non-compete culture. All right, and I could get into this extensively, and I have in some other discussions and in some other articles, but suffice to say, the problem happening here is that many folks, including, quite frankly, many judges in America, depending on the jurisdiction, are not familiar with the real doctrinal underpinnings of non-compete agreements. And by that I mean they look at non-compete agreements as pure matters of contract law, right? They say, well, look, you worked there and you signed an agreement, and I'm going to hold you to the terms of your bargain, and I'm going to enforce this non-compete agreement because you signed it. But that's not how the law is supposed to work in this arena. I have seen so many cases where a judge had said something to the effect of, well, a contract's a contract, a deal's a deal. And of course, even at the sort of most basic doctrinal level, that is not true. You can't have a contract. You can't take out a contract to put out a hit on somebody, right? And say, hey, knock off Joey, and you're going to get paid, $50,000. That contract is obviously illegal. So you can't have illegal contracts. And even though that's a sort of far more egregious example, you cannot have contracts that are in illegal restraint of trade. You just can't have that. You can't have a contract that would say, okay, we're gonna fix prices. We're gonna agree to fix prices for LCD panels. True story, it happened. It was the LCD, the Crystal Palace meetings, all that litigation. It was huge litigation, hundreds of millions of dollars, if not billions of dollars at issue, where all these different companies, all these different competitors got together and fixed the prices on LCD panels. And those are illegal contracts in restraint of trade. So the same thing with a non-compete agreement that is not reasonably necessary to protect a legitimate business interest. Now, let's get into staffing and recruiting in specific, right? So I have litigated a number of staffing and recruiting cases, and here's what I've gleaned from my experience in this arena, and from my familiarity with the case law and the matters that I've handled personally. Here's what I see. Okay, folks. Number one, the notion that there is confidential or proprietary information here is somewhat fantastical, right? Because in a lot of these, staffing and recruiting contexts, anybody and their mother can sign up to be a potential vendor or to vie for the placement, right? A lot of these companies have kind of an email list that you can get added to, or sort of website or a portal that you can get added to, where if they're hiring, if they have vacancies they want to fill that they're interested in farming out to third-party external recruiters and headhunters, a lot of these companies are willing to share those leads with folks in the staffing and recruiting business, especially if they are done on a pure contingency basis, where the staffing and recruiting company that works on the job, that works on the hire, does not get paid unless and until they find and place the acceptable candidate, and that candidate makes it for a certain number of days, called 90 days, right? The staffing and recruiting company doesn't get paid unless they deliver, right? So if you're only doing pay for performance, right, pay to deliver, pure contingency, then yeah, it makes a lot of sense to have several different companies out there hustling to try and fill the role. So I see that all the time. Most of the staffing and recruiting cases I've been involved in, there is no exclusivity, right, with respect to the placements, the roles being filled, the information being distributed regarding these open positions. The companies, the clients, are sharing these openings with a number of competitors. Now, let's be clear. If it's an exclusive placement, right? Let's say, for instance, I'll give you a very good example, right? A college presidency, right? A university presidency. Say that a search firm has been retained, like a high-end search firm has been retained to find the next president of a liberal arts college somewhere, a very good elite liberal arts college somewhere. And the current president hasn't yet announced that she is resigning. They're looking for her replacement, but it's a confidential, quietly kept process, and they've engaged a firm that they've paid money up front, because a lot of these very high-end search firms will charge money up front. So they've charged them money up front, they've retained this search firm, and it's confidential, and nobody else knows about it, and nobody else has access to that particular opportunity, because they've kept confidential the fact that the current president is stepping down and that they're searching for a replacement. Now, that is, from a market standpoint, that's somewhat unusual, because quite often when colleges and universities are searching for a new president, they will make it known so that folks who are qualified and interested can reach out and express their interest, or so that folks who are friends of the university, right, they might know somebody and be able to say, hey, I know somebody who would be a fantastic president, and he's just wrapping something up over here, and so maybe I'll reach out and talk to him. That's why they publicize these things. Why? Because competition often tends to produce the best product. But let's just go with the hypothetical and say that it's confidential, it's quietly kept, and search firm A is the only one that knows about it and the only one on the job, and they have a couple candidates in the pipeline who they think are very attractive candidates who could ultimately be finalists and potentially be awarded this position of college president, right? Let's say somebody leaves company A and they start their own staffing and recruiting company, and they immediately target the college presidency opening that we just discussed. And they wind up taking 2 or 3 candidates from company A who are in the pipeline, and then ultimately the employee who defected, who started the new company, takes the candidate and winds up getting that candidate placed as the next college president. Is that unfair competition? Potentially so, quite possibly so, because in that situation we're not dealing with sort of open, free-for-all, aggressive competition, lots of different vendors and providers, no truly confidential or proprietary information. And we even, in fact, had, up until a certain point, there may have been an exclusive relationship, right? So that's the kind of dynamic that you would need to have. That's the kind of fact pattern that you would need to have in order to really render a non-compete in the staffing and recruiting context likely enforceable. To get back to confidential information, as we laid out at the beginning of this discussion, remember, if it's confidential, unique only to the company, not available to other competitors in the market, and valuable, and could enable other companies to engage in unfair competition, then it is potentially confidential information of the sort that constitutes legitimate business interest for the purposes of non-compete enforcement. That's how it's supposed to work. So if the information at issue regarding the companies, the clients, is not confidential, if it's being shared with multiple competitors in the relevant market, then it's not confidential information that can constitute a legitimate business interest. Where in this industry are you likely to see some truly confidential information? Well, if you look at the candidate side, right, as opposed to the client side. On the client side, more often than not, I see there being robust competition, especially in certain industries. But on the candidate side, sure, maybe you will see a greater likelihood of there being confidential proprietary information, because let's say you have a roster of some candidates, some very good candidates. Let's say law firm staffing and recruiting, right? Let's say you have a roster of a couple lawyers who you are working with over the course of several months, if not more than a year. You're friends with this lawyer. You understand their practice. You understand what they're looking for. You understand the business. You understand what sort of setup they want in their next opportunity. And you've been looking to place them somewhere, to place them at a new firm for the last several months. You put a lot of legwork into this, right? And they have not done the same thing with any other recruiter, right? You're their only recruiter. If that's the case, then potentially that candidate and certain information there, you could consider that confidential information. But I'm not so sure it would rise to the level of being confidential information that could establish a legitimate business interest, because it would really have to be only known to you. And the candidate hasn't shared it with anybody else, and nobody else knows that the candidate is looking. And then you potentially have an argument that the candidate side information is confidential. But that information, again, by the same token, that information belongs to the candidate. And if the candidate wants to share it with somebody else, it is, as a result, no longer your confidential information, right? If the candidate is working with a staffing and recruiting person, named Emily, and then Emily goes to a new company, and the candidate says, well, screw you, company A, I was only dealing with you because I like Emily, and I'm going to go talk to Emily, and I'm going to give her, I have every right to give her my information, right? That to me dramatically undercuts the notion of sort of confidential or protectable information. But from a risk mitigation standpoint, you should obviously tread lightly on the candidate side of anything, not just for purposes of confidential information, but also for purposes of the second claimed legitimate business interest of substantial or protectable customer relationships, right? If you look at the the customer relationship question, obviously if the client is using multiple vendors and anybody and their mother can get in and compete for the business, and that's not a protectable customer relationship in my opinion. But on the candidate side, if it's exclusive, then that's going to go more in the direction of it potentially being protectable and substantial. It's debatable, right, if the person wanted to follow a certain recruiter. But again, as a risk mitigation technique, I would caution that you err on the side of being conservative and not solicit or attempt to take with you any of the specific candidates whose information you obtained solely as a result of employment with a particular staffing and recruiting firm. Now, it's a bit different. Obviously you can mitigate your risk and you can be as sort of risk averse as you want. But it's a bit different if that candidate is kind of wheeling and dealing and he's talking to and working with multiple recruiters. Obviously, recruiters hate that and they all try to nip that in the bud up front, but it still happens quite frequently. So next we move on to the concept of extraordinary training. You know what? I have seen in cases I've litigated, I have seen the plaintiff attempt to argue that they provided the defendant, the employee, extraordinary training in staffing and recruiting because they taught them about a certain industry, right? Like, we taught this person about law firms and about how law firms work and about how law firms hire and about different practice groups. They didn't know anything about litigation or about bankruptcy or about appellate work before we hired them and trained them. Our training is extraordinary. That's hogwash. It's preposterous. Training is one of the most, in my opinion, training is usually the most absurd and the weakest claimed legitimate business interest, because in most instances it's not even questionable, it's not even debatable, it's not even colorable. It's just, okay, the person worked at your company and learned how to do it on the job, and now you're claiming that you have some kind of extraordinary protectable interest in training. That's not how the law works, right? It has to be truly extraordinary, above and beyond, something that the person could not have gotten from any competitor, that does the same thing out in the market. And so you rarely in practice ever see a plaintiff bear out a legitimate business interest in extraordinary training. So that is, the sort of general landscape when it comes to non-compete agreements in staffing and recruiting, right? They are restraints of trade, non-compete agreements, restraints of trade, unless they are reasonable and necessary to protect a legitimate business, they should be illegal. That's how the law is supposed to work. And so in the staffing and recruiting context, let's run that through this framework, okay? Legitimate business interest, what is it? Confidential information? Certainly not if the vendor is sharing their information about openings, etc., with everybody and their mother. Confidential information regarding the candidate, possibly if it's exclusive, or if the client's exclusive or the candidate's exclusive, and there's something that truly is unique to the company that nobody else can get in on, right? In terms of substantial customer relationships, again, if the client, if the company is doing business with multiple different vendors, then it's probably not a protectable customer relationship. But there may be some protectable candidate relationships, more likely than client or customer relationships, because candidates, more often than clients or customers, will tend to be working with just one staffing and recruiting firm. You could also see some potentially protectable relationships on the client or customer front if those were truly exclusive and under wraps and nobody else had gotten access to them. With respect to training or education, that is normally hogwash, because you rarely see training in this arena, in this industry, that rises to the level of being extraordinary. Jonathan Pollard, Competition, Fort Lauderdale, Florida. Have a good day.